All right, let's go on the record for cause number DC 2016537, Wisław Rentowski versus Allstate Vehicle and Property Insurance Company. Counsel, make your appearances.
Maria Darius on behalf of the plaintiff.
Sarah Inman on behalf of defendant.
All right, this has been an interesting week because I just finished a trial where involving a property damage claim and appraisal was an issue. And so we have now another appraisal issue. It was a jury trial. So I thought this one was very interesting as well. So why don't you go ahead and start?
Sure. So this, as you know, stems from an insurance claim that plaintiff filed under their homeowner's policy. And after suit was filed, plaintiff invoked appraisal, which after having a trial on this, I'm sure you know appraisal is an alternative dispute resolution procedure. It is there to try to resolve the dispute. It doesn't determine coverage under the policy. It doesn't determine the cause of damage. It just sets the total amount of loss. And so the idea is if the appraisers go out there and set the total amount of loss, if the insurer pays for all of the damages, it would thereby encompass any potential covered damages. And so it theoretically resolve the dispute. In this suit, Allstate did pay the appraisal award. And after it paid the appraisal award, it also paid any potential interest that could possibly be owed if the damages were covered. Now, Allstate disputes that there are covered damages. It disputes that it handled the claim incorrectly, but it paid the appraisal award and interest payment to resolve the dispute. And so the only issue before the court is whether plaintiffs can pursue this litigation for the exclusive purpose of incurring attorney's fees and then trying to recover those attorney's fees at trial. We have three separate bases for the court to grant Allstate summary judgment. And I want to handle them each separately so it doesn't all get muddled. The first reason is that there are no damages that plaintiffs can pursue. The Texas Supreme Court is clear that the attorney's fees are not, the plaintiff cannot pursue litigation exclusively to recover attorney's fees. And in Ortiz, it was an appraisal case that was cited both sides, where the Supreme Court recently said that you can't pursue litigation for attorney fees. And I'm going to read a quote from it because it's very strong. Plaintiff contends that attorney fees and costs he incurred in prosecuting this suit are part of the actual damages he is entitled to recover. We disagree. Texas law is clear that attorney fees and costs incurred in the prosecution or defense of a claim, although compensatory in that they help make a claimant whole, are not damages. So in Ortiz, the Texas Supreme Court did not allow the plaintiff to pursue the bad faith claims because the only damages that they would be able to pursue there were attorney fees, since all potential damages under the claim had been paid. In Ortiz,
isn't really the plaintiff arguing that the only claim that remains is the prompt payment claim?
Yes, but the analysis still applies because in Ortiz, they didn't pay the interest. So the plaintiff in that case was able to still pursue the prompt payment claim because it could pursue interest and attorney's fees. But when the bad faith claim only went away,
does Ortiz discover the prompt? Is Ortiz a prompt payment claim case or not?
Yeah,
it is. The only claim that was remaining in Ortiz was the prompt payment claim. But in that situation, they could still pursue the interest. So that's why the Prompt Payment of Claims Act claim survived. Here, there's no interest. It's only attorney's fees. So similar to the bad faith claim, where it was only attorney's fees.
And the plaintiffs have agreed that all the interest has been paid?
Your Honor, they paid an interest check. I don't believe that it's the full amount, but Ortiz also discusses right where she's talking about that you can't recover attorney's fees for bad faith, which the court is right. We're not pursuing our bad faith claim. Literally the very next section says that the Plaintiff's Prompt Payment of Claims Act should survive. And that includes interest and attorney's fees. So I don't see any case or from the Supreme Court that says just because you pay half of what you owe, interest, not attorney's fees, that you're disposed, you don't have to pay any attorney's fees, and that extinguishes your obligations to pay attorney's fees. The Prompt Payment of Claims Act is interest and attorney's fees. It's not or, it's and.
Can you share screen that case, the portion you're discussing?
Yes, Your Honor.
Your Honor, I also want to point out really quick while she's pulling that up, the last 8 Supreme Court cases that discuss appraisal all say that the Prompt Payment of Claims Act claims survive, regardless of whether or not they pay the appraisal. And that's the last 8. There's not a single one since Barber Technologies and Ortiz that she's about to pull up that says that Prompt Payment of Claims Act would also be disposed of after a payment of an appraisal award. But I also want to point out something else. In those cases, it was a full payment of the appraisal award. In this case, they're withholding $10,000. They should have paid the full RCV amount, but they haven't. And so that, I think, opens up a lot of other causes of action. I think could also bring back a breach of contract, because if plaintiff does the repairs, which he intends to, there's really, in this case gets disposed of, there's really nothing that's holding Allstate to having to pay that $10,000 that they owe. So that's a big distinguishment from whatever cases that are discussed today from this case.
Let me ask you this though. You're not still pursuing, I thought you were non-suiting all your claims except for the prompt payment claim. You're
right, Your Honor, we are. And looking back, we probably shouldn't have, but I do want to point out that it can be brought, another breach of contract can be brought if they don't pay that full $10,000 that they still owe. I guess I'm bringing it to the court's attention more so to say that, you know, in those cases, they fully paid the appraisal award, and then they still had to pay for Prompt Payment of Claims Act. Here, we don't even make it to what the cases are that are being discussed today.
And I'm ready to share, but I just want to add that there's a big distinction between the facts of the present case and those other Texas Supreme Court cases, such as Ortiz that we're about to share, in that Allstate paid any potential interest. So the only
let me ask you this. It sounds like that's disputed, that they say you didn't pay all the interest. You say you did pay all the interest. Are there any cases that discuss situations where an insurance company paid the interest, so to speak, and on a summary judgment, and kind of how we're supposed to deal with that?
Your Honor, there's a case attached to our last reply, and it basically says that in order for that argument to prevail, I would have had to accept that that's sufficient for a settlement. So basically, it was Judge Ellison out of the Southern District, and he said Allstate had not conclusive. And in that case, I'll say that they paid the proper amount of interest. But Judge Ellison went on to say Allstate has not conclusively shown that the Texas Prompt Payment of Claims Act was resolved. Allstate's position effectively amounts to an argument that it settled Martinez, which was our client at that time, the Prompt Payment of Claims Act, but Martinez clearly disputes that argument. And in order for it to work, he goes on to say that there had to have been a mutual intent that her paying that interest was sufficient for me to amount to a settlement, or us agreeing that that extinguishes all the amounts owed under the Prompt Payment of Claims Act. And I dispute that. I mean, it's interest and attorney's fees. So again, if she owes me $10 and she pays $1 and she says, that's it, I paid you everything you need. I mean, that's not how it works. It's not enough. I had to have agreed and accepted that her interest check is sufficient to pay everything owed under the 542.
You say you filed the reply brief. Is that in the reply brief you said?
Yeah, yes, Your Honor. That opinion is one of 4.
I didn't see the reply brief. When did you file that?
Well, yesterday. It was the SIR reply to their reply. It's Exhibit 1. There's 14 orders where our firm has been successful against this identical motion filed by the same counsel. And that's the case of Martinez versus Allstate.
And Your Honor, defense has equally won just as many motions. We don't have a Texas Supreme Court decision on this issue. We have a lot of federal court opinions on this issue and some state court orders that, of course, don't give the reasoning. But there are equally as many, and the decisions are attached to Allstate's reply and Allstate's motion, in which the federal court judges agree that there are no additional damages to pursue, and that our interpretation of Ortiz is correct. That when you pay any potential interest, or and under the 542A statute, which is another argument that I want to talk about, that there are no additional damages and that Allstate is entitled to summary judgment. So full disclosure,
Well,
there are
let me ask a quick
forward.
question. So I'm share screening right now, the docket, and so there's some briefing that I haven't read yet, to be honest, because it wasn't included here. Okay, I guess it just was. So this objection to summary judgment evidence and reply. So isn't there cross motions for summary judgment here at this point?
Yes, Your Honor, there is.
And are those both being heard today?
Yes, Your Honor.
Okay. And so for the plaintiff's motion for summary judgment, which is Rentowski, you have, was that where the reply was filed, or was it on the defendant's motion for summary judgment?
It's on the defendant's. The issues really overlap though, but it was filed on the defendant's.
So just so I kind of know it, so this objection to summary judgment and reply is that what you're referring to, Ms. Inman?
No, well, yes, I think some of the cases are attached to this reply. Yes, Your Honor, sorry.
Okay, so this is to the reply to, this is defendant's reply to plaintiff's response to defendant's motion for summary judgment, correct?
Yes, that is correct.
And then you said there was a SIR reply filed to that?
Yes, Your Honor. I responded to the objections and then I filed a reply to her reply. Yes.
I don't think that's been accepted yet by the clerk's office. I don't see it here.
I think it's.
But you filed that yesterday, and that would be part of.
I thought I saw it come through.
It may just not be in my system yet. That's what I don't see it at least.
I'm happy to send it.
That's fine. Go ahead and email it to my core coordinator. Well, I haven't read the reply or the SIR reply, so I need to read both of those. Any other argument you guys wanted to make?
Yes, Your Honor. We have first with respect to the interest payment that was issued, it could not be higher than the amount Allstate paid. Plaintiff did not dispute it in their response. We erred on the side of ensuring the earliest possible time so that it could not be higher. And so plaintiff disputed that that's something that they needed to raise in their response. In addition to the no damages issue, we also have an argument that there's no coverage under the policy as a matter of law and a no evidence motion. So if it's okay with you, I'd like to proceed to those arguments as well.
Okay. Is that a separate summary judgment?
No, they're all in this particular motion. So
the amended motion.
one thing I do want to point out with respect to Allstate's traditional motion on the no damages issue is all of the Texas Supreme Court cases that plaintiffs filed are pre the enactment of Texas Insurance Code 542A. Texas Insurance Code 542A was enacted to essentially discourage wind tail litigation because it was blowing up out of proportion, and it actually outlines a specific formula for recovering attorney's fees. And under the formula, if there are no additional damages to pursue, the attorney's fees you can recover are zero. And we outline the formula within our motion, and I'm happy to elaborate on that further, but I just wanted to make sure that you were aware of that distinction. With respect to the no coverage argument, Allstate, in order for plaintiffs to be entitled to any interest, they have to show that the damages in the appraisal award are covered under the policy. And so our argument is that they're not covered under the policy as a matter of law for a couple different reasons. And the first reason is that all of these damages existed in 2015. So plaintiff had a prior claim, and in this lawsuit, plaintiff is pursuing the same damages that existed in 2015 that were never repaired. And so when the appraisers went out there to set the total amount of loss or the total amount of damages present to the property, those 2015 damages were still there. And so those damages didn't occur from the 2020 data loss plaintiff reported. And so as a matter of law, these damages aren't covered. The second point is, the second reason it's not covered is that there has to be a storm-created opening in the roof to even have coverage for the interior damage. And there was no storm-created opening that would allow for any interior coverage. And then the third argument is that plaintiff.
Wait. Okay, you're making a lot of arguments here. I don't see them in the. Maybe I'm missing them in the briefing. Is this where you're talking about in the briefing?
So this argument is, I believe, a little bit higher up in the briefing. It's above the no evidence motion.
Well, the no evidence motion is down here.
Yeah.
I think.
The no evidence motion.
You're right.
Is
It
at
says
the
no
end,
evidence motion for summary judgment.
And then the argument I'm making now is a little further up.
Okay, well, I'm not following you. So this is the no evidence motion for summary judgment. I thought you said that what you were arguing now is the no evidence motion for summary judgment.
The argument I'm making now is our no coverage argument, that they aren't entitled to pursue their prompt payment claim because the damages aren't covered as a matter of law.
Okay.
Oh, you're in the middle of it right now. I can see. There it is.
Okay. Is this it, or?
It's a little lower.
Maybe, can you give me a page number?
Yeah. It starts on page 15.
Okay.
And so
This says independent of appraisal, Allstate is entitled to summary judgment. Is that what you're arguing right now?
yes, Your Honor. And the argument is that we're entitled to summary judgment on the prompt payment claim because as a matter of law, the damages aren't covered under the policy. So Allstate went ahead and paid the appraisal award when it did not have to resolve the dispute, but plaintiffs can't pursue the prompt payment of claims act claim because they would not be entitled to the interest no matter what, because those damages would not have been covered under the applicable policy. And the first reason I discussed is that those damages existed in 2015. And the second reason is that there's no storm created opening in the roof, which plaintiffs did not, the interior argument plaintiffs did not respond to. And the third argument is that plaintiff has a duty to protect the property from further loss and make repairs, and they didn't do that. So their prior breach means that they can't pursue their breach of contract claim. And I think that the only evidence that plaintiff has in response to the coverage argument and into Allstate's no evidence summary judgment argument is the affidavit of Bobby Croson, who is one of the appraisers in this case. And so Allstate filed objections to it. And I think that the objections and arguments to his affidavit are going to be really important in the court deciding this, because the affidavit is very conclusory in that it just says the damages are covered, period. I looked at the damages, they're not the same as the damages in 2015, period. Therefore, they resulted from the storm. And so we cite a Texas Supreme Court case that says specifically that ipsy dixit statements by witnesses or conclusory statements without any analysis are not sufficient to raise a fact issue to a summary judgment motion. And I actually have some photos that I want to screen share from 2015 to show how the analytical gap in his affidavit is missing, because clearly he did not consider that the potential of those damages. He did not consider that those.
Is this the right response? I should have probably asked you guys to do a briefing notebook, because it's very unclear in here what is responding to what. But is this the response you're talking about?
Yes, there's an affidavit attached to plaintiff's response, and that's the only evidence that they produce in response to Allstate's no coverage argument and Allstate's no evidence summary judgment motion.
That's this one here, the declaration of Bobby Croson.
It is. And so Allstate has filed objections saying that it's an ipsy dixit, it's just conclusory. He doesn't include any analysis. He doesn't discuss whether he even accounted for the damages in 2015. He just says, I looked at them and they're not the same. And so I wanted to show the court some
So
of the
it says
photos
here that it says on paragraph 7, I'm aware that Allstate contends that the damages to Rentowski's property are not covered because they predated the March 15, 2020 storm. Allstate attaches photos its adjuster took when Allstate evaluated the 2015 claim and states that the photos reflect the damages to the same areas existing that I guess existed before March 15, 2020. I reviewed the 2015 photos containing the exhibit A13. The defendant's amended traditional and no evidence motion for summary judgment. Those photos do not fairly and accurately represent the condition of Rentowski's roof or the interior damage at the time of my inspection. Further, with respect to the timing of the hail damage to the roof, when the Allstate appraiser and I inspected the roof on or about March 25th, 2021, we agreed that damage occurred within the last 2 years. So I don't, how is that ipsa dixa?
Because he's just asserting without any analysis. We have the photos from 2015. He could have attached photos to show that they were different. He could have had the basis to explain how he determined that they occurred within the past 2 years. He didn't do that. He did not explain how the damages that were present weren't the construction issues that Allstate identified versus storm damage that he asserts that they are. I mean, there's a million questions that are not answered by his affidavit.
Well, let me ask you this. Did you submit an affidavit from that adjuster that said they did not agree?
We did submit, we submitted the claim findings, and our corporate rep proofed up all the business records we attached with all the adjuster's opinions. And
I'm sorry, not the adjuster, I guess the Allstate appraiser. So he says that the Allstate appraiser agreed with him that these damages occurred within the last 2 years.
So
did you submit an affidavit from that appraiser that said, no, we didn't agree?
We did not submit an affidavit from the appraiser. And actually, the Texas Supreme Court and Court of Appeals opinions are clear that evidence from appraisal cannot be used. And that's a separate argument that I was planning to address later on, in addition to the objections. But you're not supposed to use evidence of the appraisal process itself. And the idea is that appraisal is an alternative dispute resolution procedure. And so if you can use the appraisers, their documents, the appraisal process to establish liability, then an insurer would never agree to participate in the appraisal process. And so we actually cite a couple cases that say that. Plaintiff's counsel filed, has done something similar in the past, and the decision went all the way up to the Fort Worth Court of Appeals. And the Fort Worth Court of Appeals, in citing the Texas Supreme Court, said you can't do this. You can't find a back door to use the appraisal process when the Texas Supreme Court has specifically shut the front door to using the appraisal process to establish liability. And so the evidence Allstate relied on is the claim handling document. So the findings from the appraisers, the 2015 photos, the claim handling notes, that type of thing, which is appropriate evidence.
Okay, I'm going to overrule those objections. Anything else we want to talk about today?
I'd like to briefly address motion for summary judgment that plaintiff has on file. They are overlapping issues. I'm basically saying that this was a covered loss under the policy, and so I'm entitled to summary judgment on my Prompt Payment of Claims Act. And just really quickly, I mean, it's pretty self-explanatory from the evidence attached by defendant. I mean, the interest checks say that it is for a wind date of loss and wind damages. Wind damages are explicitly included in the policy as covered damages. It shows that it's for the actual claim, the property. I mean, it's a claims payment. It looks like a claims payment, smells like a claims payment, because it is a claims payment, because it's money that they owed to Mr. Rentowski under the policy. So just based on that alone, I think there's enough evidence to show that they owed this. Obviously, they paid on it and then they paid interest on it because they owed it. And so I'm entitled to summary judgment on my Prompt Payment of Claims Act if they were liable for the claim, which they've more than sufficiently shown on their own.
Response, Ms. Inman, to her motion for summary judgment?
Yes, Your Honor. When Allstate paid the appraisal award, it sent a letter specifically stating that it was not accepting coverage, it disputed liability, but it was paying the appraisal award to resolve a dispute. And it was also paying the interest to resolve the dispute. It was very clear that in paying the appraisal award, Allstate was not accepting liability for the claim. The Texas Supreme Court and Barber Technologies said that an insurer has the right to pay an appraisal award to resolve the dispute without accepting liability. We did exactly what the Supreme Court says that we have the right to do, and the Texas Supreme Court is clear that that does not establish liability. The payments reference the claim number and the specific loss because they are payments specifically to resolve the dispute over that claim and that loss. That's it. So other than the fact that it references the claim number and the reported date of loss, there's no other indication that Allstate would be accepting any type of liability for the claim. Allstate explicitly stated that it wasn't. I think the law is very clear. If you look at the Texas Supreme Court decision, it says that you cannot use appraisal to establish liability and that an insurer has a right to participate in this alternative dispute resolution procedure to resolve the dispute.
Really quickly, Your Honor, I just want to point out some of the disingenuous arguments that have been presented. So a plaintiff is not allowed to use the appraisal award, the appraisal payments, anything to basically at all today, but Allstate's basically using the payment of the appraisal award to try to get summary judgment on all of plaintiff's claims. I do want to point that out because it's just interestingly disingenuous. And then there's another point that I did want to make really quickly. In their response to my motion, they admit at the very least there is a fact issue that such damages are not covered. I mean, if there's a fact issue as to liability, then I don't know why they even presented any motion for summary judgment today at all. They're admitting it. I don't think there is. I think it's pretty clear that it is covered and that they owed this money and that plaintiff's entitled to summary judgment, but I don't know how defendant can ask for summary judgment when they're admitting in another motion presented today that there's a fact issue. So I just wanted to point those out to the court quickly.
Your Honor, there's a fact issue, and we have to say there's a fact issue in response to plaintiff's motion for summary judgment, but it's clear from our motion that we don't think that there's a fact issue because the 2015 damages existed in 2020. We have photos attached to our motion that show that it is very clear that the same damage to the roof existed in 2015 and 2020. So, of course, we have to raise a fact issue in response to plaintiff's motion, but we think that the evidence is clear that there is no fact issue. And I want to point out that the Texas Supreme Court said you can't use appraisal to establish liability. And there's things that we could show to the court as evidence to get summary judgment that we would not put in front of a jury. And the distinction is in the case law that says it can't be used to establish liability. And so that's the distinction between plaintiff's motion and Allstate's motion.
All right, I'm going to take these both under advisements. When is this case set for trial? I can look it up if you don't know. You know when it's set for trial, guys?
I don't. I'm trying to find it, Your Honor.
And not until May. Okay. Sounds good, guys. I'll get you a decision within the month, okay?
Thank you.
Thank you.
Thank you, guys. You are excused.
Thank you, Your Honor.
All right, is everyone here an Angel Sword? I think I saw Mr. Vassar.
I think all the attorneys are here, Mr. Henley and Mr. Ellis.
Mr. Ellis, okay.
I'm here, Judge.
All right. Let's get, do we want this? This is a motion for continuance. We don't really need that on the record, I don't think. But do you guys want to go ahead and make your argument?
Well, it's an agreed motion, right?
It's an agreed motion, Your Honor. You may recall we were before you on July 2nd, 3 weeks ago, and you, asked us if we wanted to move the trial setting of July 27th. Nobody really committed to it that time, but you also ordered a Sunday deposition, and after some reconsideration, we all agreed to a motion. I believe that Mr. Henley would like to try to get a special setting. Don't know how possible that is in this environment. We're not necessarily opposed to that, but I think he probably would want to have something to say about that.
That's right, Judge. I mean, these parties, as we've contended from the beginning, we don't believe this lawsuit belongs here because the essential core parties are out of town. And as a result, since we're going to have to move heaven and earth to get these people here, I was hoping that we would, have a day that's a little bit more certain, even though, special settings may not be in vogue anymore because of COVID, et cetera, at least some indication, as opposed to having to wind people up and bring them here or not, because we probably would need at least 3 or 4 people that I can think of that may have to come in from out of town.
I mean, I could specially set this maybe next May. I mean, would you prefer that, or do you want to try to set it sooner? Do you want me to see what your likelihood of going next week is? Because
I think the reason why we agreed to do that is because you, and this is what opposing counsel and I kind of been talking about, you actually went through your docket with us last time and indicated there I believe was either 9 or 11 cases in front of us, and 2 of them toward the top seemed like relatively complex disputes that I think that you had said that there had been a fair amount of motions practice on it. And so
things change. Let me just see what we have ahead of you now. Right now you're 1, 2. Oh wait, you're not. Yeah, there's quite a few. 1, 2. 1, 2, 3. 4, 5, 6, 7, 8, 9. Yeah, okay. There's quite a few cases ahead of you. Yeah, you'd be about number 10 at this point.
And you had done that for us before, which I thoroughly appreciated, and that was something of an inducement to me. As much as I'd rather always move things, it seemed like a vain exercise to.
And I'll say at this point, this could change, but my current plan is just to call down my 2018 and 2019 cases next week, and this is a 2020 case. So I don't anticipate I'd even call you guys down again unless something significant occurred and a lot of other cases went away. But I'm not opposed to moving it. But when would you guys like to be reset?
A date with some surety, Judge. That's what everyone wants. With just the cost of ramp up is going to consume the value of the case, and our concern would simply be a date that we think we can reasonably get reached. And
is there still a receivership request in this case, or has that been dropped?
No, well, we still have that. Your Honor had indicated, we had wanted it immediately. Your Honor was like, well, let's see how the trial bears out. But no, we're still wanting, judicial oversight of the or third party oversight of any kind over the entity, specifically.
Yeah, I'm not making a ruling on that today because I would want to hear argument and all that stuff. I'm just wondering if that's still an issue.
It is.
And have you thought about like who would you want an attorney to be the receiver in this case? If I was to grant a receiver, this is kind of such an unusual case.
Right. You're not. Yeah. I don't know that we would want to necessarily a swordsmith, but whether it's an accountant or an attorney, some sort of paymaster, somebody to go back and look through the books and, obviously, even though that very well could end up depleting, a fair number of the assets. Right now, our position is that's happening already, and it's completely unilateral. But what I'm looking for is some sort of a cop who has some accounting.
And Your Honor, last time when you had that before you, there's a published case out there that you recalled that we mentioned in our briefing where, that was after a jury trial. And I think that's what kind of got some of this, oh, we need to try everything going. And so, that's kind of where we are.
And I don't know that that was a requirement. I think that Your Honor was thinking that that's a better idea. That
yeah, for a wind-up receiver, for sure, I'd probably want a trial on that. But whether or not you need a receiver to kind of manage the business until then is the issue. But so so you have a couple options here. We can specially set this next May and you'd have some degree of certainty, or I can just set you in, we're just what I'm doing with most 2020 cases is just setting them in 2022 and hope that I'll get to them. I don't know if that's going to happen or not. We had 27.
That being said, I'd be happy to take the May date then.
I believe so, yes.
Now that you've helped us with that.
Well, I mean, I'm not trying to be
No, Judge. I know you're not being, cagey or anything like that, but that tells a lot, and I would rather because if it's a difference between February and May, that's certainly manageable, but I think certainty is what appeals to me the most.
Us too, Your Honor. I think we'd take the May.
Okay, let me just look something up real quick. And let me just give you my speech I give to everyone I give a special setting to, and that is, if you have a special setting, you are going that day. So make sure that you have all your discovery done, mediation done, unless there's a death of a critical party, you're going to trial then. And so I would suggest May 17th or May 24th or May 31st.
I think May 17th is perfectly fine.
What'd you say, May 17th?
Yes, Your Honor. I said May 17th is perfectly fine.
I apologize. Yeah, May 17th is right. Okay. Okay, so May 17th, we'll go ahead and specially set this case. And anything else we need to chat about?
Do you want us to give each other cross notice of this, or is this fine with you? Or
we're sending you a trial notice.
Okay. All right. Well, thank you, Judge. I don't have anything else.
Okay, guys. And if you want that the receivership thing, why don't we chat just real quick about what type you want, an accountant as opposed to an attorney? Or
an accountant would be perfectly fine. An attorney would be just as, would probably be preferable. But
what I'm thinking of, okay, so there's 3 guys I use mostly for receiverships. They're all pretty expensive. This is a smaller case. there's a younger lawyer. He's over at Wick Phillips. I don't know if he'd want to do this, but he's kind of, I think, understands this, would understand this dynamic in terms of the industry, I guess. He'd understand the industry a little bit more. You know, or we could even go with somebody younger than him. I'm thinking of an even younger lawyer.
Yeah, if I could just, I mean,
I'm not disappointing anybody.
Receivership, and
what'd you say?
We're opposed to the receivership.
I know. I'm just saying, if we get to that point, I want to be able to have somebody in line if that comes up. So, I'm just trying to get a feel for it if it comes up.
This is a discovery effort by Mr. Henley and his client.
No, it's not.
They're looking for. I do a lot of receivership work, and this is an effort to just. There are no allegations of inappropriate conduct within the company. This is a battle over claim of ownership, not a waste of assets. That's not.
No, that's absolutely.
And this is just a discovery effort by Mr. Henley. So he's going to want an accountant to go back in time and try and unwind the theft of his client. He's going to try and somehow find something he can latch onto. So that's who they're going to want as a receiver. This is not a sincere effort to say there's something going wrong with the company.
Okay, Judge.
I want to make it clear, I'm not letting Mr. Henley choose the receiver. So I'm not going to let him use this as some way to, cover up misdeeds. That's not the role of the receiver. I'm going to appoint an independent receiver.
It's just a threshold question, Your Honor, whether.
No, I get that. I'm just trying to say, if I don't have a receiver, I've never had a case where somebody had to take over a forge. And so this is kind of unique. And so I'm trying to think through, if I have to do that, who would be the right person to do it? And that's all I'm thinking of, is just, the normal folks I appoint are all pretty expensive, and I don't think would be right for this case. So that's all I'm trying to say. I don't need to confer with you on this. I mean, I'm just trying to get your input if you have any. But I have a couple of ideas on who I might want to appoint. But you're right. I'm not appointing them now. I'm just kind of thinking out loud. So, guys, you guys have a great weekend, and we'll especially set your case, and hopefully everything will get worked out. And have you guys you've been to mediation already on this, right?
No, not in this case. They've went in the family law case. But Judge, if I may, this is not a discovery attempt, and I do take umbrage at the notion that this is used for that purpose. My client has been shut out of this business for the last, since about 2017, and has absolutely had no way to ascertain how much she has lost. And again, we need a cop of some kind. And I agree with Your Honor that, we probably don't need a white shoe lawyer to ascertain the value and the waste or application of resources for a forge in Central Texas, but we do need something. And our side is perfectly content with whatever this person unearths. We have nothing in the least to hide.
All right, guys, great. I'm not.
Thank you, Judge.
Today, so
Thanks,
we got you reset, and you guys be safe, and we'll see, I'm sure, soon if this case is any indication. So,
all right, take